Good morning. Thank you so much for being here today. I am very grateful. This is the first time that the Pro-Life Center at the University of St. Thomas has reached out to high school students. And I've got to say that I think both Professor Paulson, who is co-director of the Pro-Life Center, and myself believe that you are the future. I just got back from the March for Life in Washington, D.C., where there were literally hundreds of thousands of young people, and clearly my age group was in a small minority. So we are delighted you're here. Whether you're pro-life or pro-choice, we hope it's educational for you, and are very grateful for the faculty members and others who made it possible for you to attend. Before you came in, you were handed a document, the Retrial of Roe versus Wade. So I'd like to sort of go over it with you and explain to you what's happening as you begin to see it. Many of you may have already studied or at least looked at the question of whether abortion should be a part of constitutional law, but this handout sort of outlines where we are in the country today as a matter of constitutional law. The way we're going to proceed is it is based on a case in which the federal government has outlawed abortions based on the sex or the race of the child. That proposed legislation is actually pending in Congress at this time. And last spring, the House of Representatives voted not to pass the bill out of the House, although a majority of the congressmen and congresswomen voted for the bill, but they had raised the bill to the floor in a unique procedure that requires a two-thirds majority. So at least in the House of Representatives, we know that more than half of our representatives believe that abortions should not occur in this country, at least when they are based on the race or the sex of the child. One of the arguments that opponents of the bill made is that the bill on its face is unconstitutional, and that's why I prepared this handout. So let me just walk you through it. As many of you know, Roe versus Wade, a case decided by the United States Supreme Court in 1973, created a fundamental right to abortion. Now, that phrase is a special phrase for lawyers, because if something is a fundamental right, the government can't interfere, regulate, or prohibit the activity absent some extraordinary circumstances. So, the fact that the court characterized it as a fundamental right made it among the most protected rights that we see in our country, comparable to free speech, comparable to free exercise of religion. Some would say, in fact, given greater weight even than free exercise for religion. And they did it by arguing first, courts don't argue, they opine, by opining first that whether or not the unborn child was in fact a person entitled to constitutional rights was a question that was undecided, and that the court simply wasn't wise enough to decide on a question that they suggested was not even decided among theologians, among medical people, and others. And based on that, they said that that which is within the woman is merely potential human life, not a human person that should be protected by law. And so they set up what is called a trimester system. They said that in the first trimester, many of us tend to think of it as 3 months. Technically, that's not correct, but close enough. The first 3 months of pregnancy, there can be no regulation or prohibition of abortion. That women are free to obtain abortions with consultation of their doctors under whatever circumstances they believe are appropriate. And in that second trimester, months 4, 5, and 6 of pregnancy, well after the unborn child has developed a heartbeat, well after it's begun to quicken, at least in the last half of that period, the law could not protect the fetus, but could merely protect the woman's health. It was only after the fetus, or the unborn child, had achieved what the court called viability that the state could prohibit abortions. And while the court didn't really articulate its reasoning in Roe versus Wade, ultimately we came to understand it was based on the simple reasoning that if a woman could be free of her pregnancy through childbirth, then there was no need for her to resort to abortion. She had already gone through what the court characterized as the dangerous process of pregnancy. They said, however, that even in those last 3 months, months 7, 8, and 9 of a pregnancy, that the state could prohibit abortions that were not necessary for the life of the mother or the health of the mother. And here's where the rub comes. On the same day that Roe v. Wade was decided, the court was examining a Georgia statute that regulated abortion and required 2 physicians certify that the abortion was necessary for the health of the woman. The question came up, what exactly does it mean to be necessary for the health of the woman? So, what the court defined health to include was all factors: physical, emotional, psychological, familial, and the woman's age that are relevant to the well-being of the patient. It's on that definition that most of us in the pro-life movement argue that the court virtually swept away any ability of the state to protect the unborn even on the threshold of birth. Because if a woman can obtain an abortion even in the 7th, 8th, or 9th month for her psychological health, well, as one physician who provides abortions testified in Congress, there's not an abortion done that isn't because of the woman's psychological health. If she doesn't want the baby, that means her psychological health is at stake. So that definition essentially created a loophole that made it impossible to protect the fetus or the unborn child even in those final stages of pregnancy where the child could have been born and placed up for adoption. From 1973 to 1992, then the court reviewed legislation that states had passed in an attempt to try to regulate abortion. Common sense things like requiring women be told that there are alternatives to abortion, that there are resources available to help them if the problem is that they lack money or housing or medical care. They struck down the rule that a woman should be informed of potential risks of abortion, as well as the basic customary requirement that particular medical procedures be reported to the Department of Health so that we can determine their impact on the patients that are receiving it. So we went from 1973, where the court said that in theory we could regulate abortion in months 4, 5, 6, 7, 8, and 9, but then created this huge loophole, to a time when, under Thornburg, the court virtually struck down any legislation that would limit or regulate abortion in any way. What changed in 1992 is the case of Planned Parenthood versus Casey. In that case, in a split opinion, in which no 5 justices agreed with the reasoning behind the holding, the court stated that they no longer would go toward the fundamental right, super protection of the right of abortion, and instead move to a balancing test, a test that they called the undue burden test. That's the long quote near the bottom of the page, where the court tries to explain what an undue burden test is. They say it's shorthand for the conclusion that the state regulation has the purpose or effect, and here's the important paragraph, of placing a substantial obstacle in the path of a woman seeking an abortion of a non-viable fetus. If that's the case, if the court decides that the law creates a substantial obstacle to a woman seeking an abortion, it's unconstitutional. After the case came down, frankly, those on the pro-choice side and those on the pro-life side both criticized the court for simply saying that that's an impossible standard. Legislatures cannot know in advance what's lawful and what's not. But under Casey, the court seemed to narrow its opinion as to the 3rd trimester and said that post-viability abortions, abortions in the months of 7, 8, or 9, can be prohibited except where necessary to protect the mother's life or, and here's the narrowing, where necessary to avoid a substantial impairment of a major bodily function. Notice that by that definition, they've eliminated the psychological, They've eliminated the familial, at least in theory, under the new definition of health. They've eliminated the emotional. So, that's the state of the law today. The question under constitutional law today, when a state tries to regulate abortion, as some states have done by requiring ultrasounds be shown to the woman prior to her abortion, or requiring that women be informed of the possible risk of suicide following an abortion, the standard the court has to look at that law under is whether it creates a substantial obstacle to the woman obtaining her abortion. Laws are often attacked also for the absence of a health exception, but now the court will look to see if abortion remains available in that third trimester as well as throughout the pregnancy for the sort of substantial impairment of a major bodily function. In our imaginary case today, I will be representing the United States of America. It's clearly an imaginary case because the United States of America is asking for reversal of Roe versus Wade. All right? Our current administration would never take that position. My opponent, Professor Michael Paulson, an internationally known pro-life scholar and former counsel to the White House, I'm sorry, one of our judges is counsel to the White House, counsel to the executive, to the president? Yes, former counsel to the president will be arguing that the law is unconstitutional and that Roe versus Wade should remain intact. Remember, for purposes of our discussion today, the law that's at stake is whether or not Congress could pass and enforce a ban on those abortions at any time in the pregnancy where the woman is seeking it because of the sex or the race of the baby. That's the law that we're arguing about. At the bottom of the second page, you'll see an outline of my argument. On the third page, you'll see an outline of Professor Paulson's argument. You'll also have a chart at the back that we developed from the actual congressional hearings on this law that provides you the arguments that were made in Congress that ultimately defeated passage of this law. Finally, on the very back of your handout, that final page, is a student judging sheet. The judges for today are Professor Robert Delahunty, who has also served in the Office of Legal Counsel to the President, as well as White House counsel, and Professor, I hope someday, Mr. Kevin Keneally, who is a partner at Leonard Street & Diner, one of our finest firms in Minneapolis, St. Paul. He's an expert litigator, and they will act as our judges, questioning us about the position that we are taking before the court. We'll be assisted by law student Sarah Schaefer, who is a law student at the University of St. Thomas, who has an interest in this area of law. Her primary role will be to make sure that the lawyers stay on time so that we'll have plenty of time for questions and answers afterwards.